appear. And this honorable court, the Honorable Marino J. Rossinese Jr. now presiding.
Good afternoon.
Please be seated.
I hope everybody's in the right courtroom. Am I supposed to be here? All right, they had me scheduled for 5. I came in from the youth center and went down there and I was by myself. So I guess this must be the place. All right, we have a civil matter on tap this afternoon. Where are the plaintiffs? Okay, you ready for your opening argument? Okay.
May it please the court, Your Honor, counsel, ladies and gentlemen of the jury. My name is Matthew Reber, attorney for the plaintiff. I'd like to introduce my co-counsels, Liz Braha and Brad Davis. Today's case is about a fire that destroyed the business and 5 hard years' work of my client, Mr. Terry Fink. During the course of this trial, we will prove that it was the negligent actions of Darrell Claiborne that caused this fire. As the judge will instruct you, negligence is defined as the failure to do something that a reasonably careful person would do, or the doing of something that a reasonably careful person would not do under the circumstances. You will see that Darrell Claiborne's actions fulfill both these definitions. The plaintiff is not trying to attack Darrell Claiborne's character, but simply present the fact that through his negligence on the night of August 7, 1993, my client's auto body repair and paint shop burned to the ground. The negligent actions of Darrell Claiborne are clear. First, he trespassed on the private property of my client, Mr. Terry Fink, gaining access to a locked fence that clearly displayed a no skateboarding permitted sign. Then, he broke a paint shop window with his skateboard, which first knocked over paint cans, releasing their flammable fumes, and also allowed cold night air to enter the building. This night air caused the heater to stay on much longer than it would have normally, and also allowed air to circulate within the building, which caused the flames to spread. Finally, Mr. Claiborne failed to inform the police of his actions until the day after the fire, and only then after being contacted by the authorities. Darrell Claiborne could not produce his skateboard at this point, and in fact still cannot produce his skateboard for this court. It seems more than just coincidence that, upon investigating the fire, Fire Marshal Blaze Weed found the charred remains of his skateboard next to overturned paint cans, that Darrell Claiborne's skateboard is the only one known to there in the premises by his own admission, and that Darrell Claiborne has not been able to produce his skateboard since the fire. Today, the plaintiff will call 2 witnesses, Mr. Terry Fink, the former owner of Fink's auto body repair and paint shop, and Tracy Attila, a local youth who was also present the night of the fire. Mr. Fink will testify to his experience with this business and also to his efforts to keep skateboards off his property. Tracy Attila will confirm Mr. Fink's efforts and testify to the actions of Darrell Claiborne on that night. The only expert witness to be called today is the Fire Marshal Blaze Weed, and he will tell you the role of Darrell Claiborne's skateboard in causing the fire is likely. As you may have noticed, Darrell Claiborne is not the defendant in this trial, but rather the suit has been brought up against his mother. This is because of a Pennsylvania statute which deems parents liable for the negligent actions of their children, and also states that such suits be brought against the parent. Also, this is a bifurcated trial, and damages are not an issue at this point. At the conclusion of this trial, we will have proven the negligent actions of Darrell Claiborne and a direct relation between these actions and the fire that destroyed Fink's auto body repair and paint shop. With this in mind, I ask that you find in favor of my client, Mr. Terry Fink. Thank you.
Thank you, counsel. Defense.
Thank you, Your Honor. Good afternoon, Your Honor, ladies and gentlemen of the jury. My name is Kristen Ritter, and here with me today are my co-counsel Rosanna Termina and Mike Kaczynski. Together we represent the defendant, Darrell Claiborne. Because Darrell is a minor, his mother, Lynn Claiborne, has been legally named as the defendant. Darrell Claiborne is a 16-year-old who lives near Fink's Auto Body, a garage owned by the plaintiff, Terry Fink. My client is being sued by Mr. Fink because Mr. Fink believes that Darrell caused the fire which burned down his body shop. Mr. Fink believes that Darrell caused this fire by skateboarding. On the night of August 7th, 1993, Darrell and some friends decided to go skateboarding together. They went to Mr. Fink's property because there was a good hill there, and because some of them had skateboarded there many times in the past. At a little after 7 o'clock, they arrived at the garage and entered the property through a large hole in the makeshift fence that Mr. Fink had only recently tried to construct. While making his first run down the hill, Darrell fell and his skateboard flew out from beneath him. It went through a window in the garage, breaking the window and dropping to the floor inside. Darryl used a piece of wire to fish out his skateboard, and he found that it was badly damaged. He used the wire to try and fix the skateboard, but when he realized that it was beyond repair, he threw it in the trash dumpster and went home. Darryl admits that his skateboard broke the window, but he has accepted responsibility and paid for the broken window. He will tell you that he saw no indication that he and his friends were unwelcome there, and that no one had prevented them from using the hill in the past. The skateboard was found in the garage after the fire. Mr. Fink will claim that this skateboard was Darryl's, but Darryl will tell you that it wasn't. Blaze Weed, the fire marshal for Centerville, will tell you that it doesn't matter whose skateboard it was, because the skateboard wasn't the real cause of the fire anyway. Blaze Weed investigated the fire at Fink's garage. After her investigation, she prepared a report. She will tell you in detail the circumstances which surrounded the fire. She will tell you that her investigation found paint cans and cleaning products, all flammable chemical compounds, located only 3 feet away from the heating system, and a stack of newspapers lying only 1 to 2 feet away. Blazeweed noted in her official report that Fink's garage had previously been cited by state authorities for storing flammable products too close to the heating element. Blazeweed said in her expert report that she could not find any conclusive indication that the skateboard, whoever it was, played a role in the origin of the fire. What she did conclude is that the most probable source of the fire was the combustion of fumes from open paint cans and cleaning products, which were ignited by Mr. Fink's own heaters. Mr. Fink will testify today as well. You will see that he knew that the skateboarders were using his property, and that in fact he enjoyed watching the kids perform. On July 6th, a month before the fire, Mr. Fink noticed that his homemade fence had come apart. He never bothered to repair the gap in the fence, even though it was apparent that people were getting through the fence and onto his property. As Mr. Fink was leaving to go home for the night, on the night of the fire, August 7th, Mr. Fink turned on the heating system in the paint shop, where the flammable chemicals were stored. At the end of the case, the judge will instruct you in detail as to the definition of contributory negligence. He will tell you that this is when the accident is brought about by the plaintiff's own carelessness. We are confident that you will find that this fire was caused by Mr. Fink's negligence. It was his heater igniting his chemicals that burned down his garage. And after you hear all of the evidence, you will determine that it was his fault. Thank you.
Thank you, Pat. Call your first witness.
May I call Mr. Harriton?
Place your right hand on the Bible, state your full name,
Terry Fink,
spell your last name.
F-I-N-K.
You swear testimony about to give the court a minute, I'll try and answer with the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Please be seated.
Right.
Mr. Fink, could you please introduce yourself to the jury?
My name is Terry Fink, and I am the owner and I'm 25 years old. I'm the owner and operator of Fink's Auto Body Repair and Paint Shop, which I've now owned for 5 years.
And what experience do you have in this kind of business?
I graduated from Vista County Votech School in 1985, and upon graduation I worked for 2 years for the unlicensed Ford of Mercury, which is the Ford dealership here in Centerville. After those 2 years, I decided to venture out and start my own business.
Prior to the destruction of your business, did you have any employees?
Yes, Chris McHugh and Tony Savage served as my auto body employees. Kelsey Mathio was my secretary and bookkeeper, and Sam Enders used to be my paint technician until I was forced to terminate his employment.
Now, you've stipulated to receiving a DER citation. Could you please explain to the court the nature of this citation?
Yes, I was cited for having flammable products too close to the heating elements.
And who was your paint technician when you received this citation?
Sam Enders.
Is he still an employee of yours?
No.
Have you received any citations since firing Mr. Enders?
No.
Had you been aware that kids were skateboarding on your property?
Yes, I was aware that they skateboarded during the day.
And when did you learn that they were skateboarding at night?
Well, a few weeks before the fire, a friend of mine, Tom Columbus, who was having his car painted, he asked me if I was aware that they skateboarded at night. He's an insurance adjuster, and he told me that I could be liable if one of the kids were injured on my property.
And what did you do to remedy this problem?
One of my employees and I went out and built a fence, and we put a padlock on this fence. We also put up a no skateboarding permitted sign, and this was completed on July 2nd, 1993,
What was the purpose of building this fence?
to keep the skateboarders out.
Did you ever actually go and tell the kids they couldn't skateboard on your property?
No, I thought a no skateboarding permitted sign and a padlock gate was sufficient.
Could Could you please tell the court what happened on the night of August 7th, 1993?
At about 11:50 p.m., I received a call that my garage was on fire. I immediately went over and I saw 5 years of hard work burned to the ground.
Mr. Fink, could you please identify this diagram?
This was my auto body repair and paint shop. Everything's accurate except for the fence and the no skateboarding permitted sign.
Your Honor, I'd like you to introduce this as an exhibit.
Any objection? What is it, Counsel?
It's a diagram of Mr. Fink's auto body.
Exhibit 3. All right. Exhibit 3 is admitted.
Mr. Fink, could you please identify the portion of the shop where the fire began?
That was the paint shop area. I was pretty surprised to see the fire had started there, considering that's the only part of the building that's not wood construction.
And could you please identify where Daryl Claiborne's skateboard entered the building?
In the paint shop area.
Okay. Did you lock the fence the night of the fire?
Yes, I clearly remember locking the fence.
And did Daryl Claiborne admit that his skateboard broke your window?
Yes, you did.
Thank you. Your witness.
All right, cross-examine.
Mr. Fink, before you put up your fence, you mentioned that you didn't mind that the skateboarders used your property, correct?
No, during the day, yes, I didn't mind.
You said you even enjoyed watching them skate, correct?
Yeah, I did.
Now, when you put up your fence, you used materials you found from a junkyard, correct?
Mm-hmm.
And you say that this fence made out of spliced together junk was supposed to keep the skateboarders out?
Oh, yeah, and the no skateboarding permitted sign.
Now, you never verbally told Darryl or any of the skateboarders that they were not allowed to skateboard on your property, correct?
No, I didn't need to. I put up the sign and I had a padlock gate.
Well, in fact, even after you put up the fence, you still said nothing to them about being allowed to skateboard on your property, right?
No, nothing verbally, no.
Mr. Fink, on July 6, 1993, that's 4 days after you put up your fence, you noticed that it had a hole in it, correct?
A small hole, yeah, I did notice it.
You never bothered to repair this hole?
I didn't think it needed repair.
In fact, you say you forgot all about it, correct?
Yeah.
And maybe one of the reasons you forgot about it was because that same day you were visited by the Department of Environmental Resources, the DER, correct?
Objection, relevance.
Go ahead.
We believe, although we stipulated to one report in the facts of the case, that Pat's negligence is not indicative of his negligence in this trial.
Your Honor, first of all, the plaintiff has brought this up in their direct testimony, whereas I think I should be able to cross-examine him on it. And furthermore, we're not trying to use this specific instance to prove any negligence that day, just that he knew that doing something was wrong.
All right, I'll overrule the objection. I think plaintiff opened the door by putting the stipulation in the first place. Secondly, as counsel indicates, and at least his own hearing, it's not used to show that negligence on that evening. Members of the jury, let me caution you, however, that by virtue of the fact that there was behavior in the past that may or may not have been condoned by the Department of Environmental Resources, that is not to be taken by you in any way as being negligence on the date in question. All right, you may proceed, counsel.
On that date, the Department of Environmental Resources came to visit your garage to check your compliance with your storage of hazardous chemicals, correct?
Yes,
And on that day, they issued you a citation, correct? Your Honor, may I approach the witness? Mr. Fink, I'm showing you what's been marked as Exhibit Number 2. Your Honor, here's a copy. Opposing counsel is saying a copy. Mr. Fink, this is a copy of the citation that they issued you, correct? And your violation was due to the, quote, placing of paint products too close to the heating elements, correct? Now, in addition to this citation, you were given a fine, right?
Yeah.
And this fine was for $1,000, correct?
That's correct.
Mr. Fink, this wasn't your first citation that you had been given by the DER, correct?
No.
In fact, this was your third consecutive citation for the placing of flammable chemicals too close to the heating element.
Yeah.
Okay, Mr. Fink. On August 7th, 1993, before you left work, these heaters that were specified in the DER citation, they were left on, weren't they?
Yeah, so the car's paint can dry.
Okay, Mr. Fink, let's talk about the other children who were found on your property that night. You have entered into some sort of financial arrangement with the 3 other families, correct? So, Charlie Meyer's parents have paid you $250, correct? Pat Scott's mother has paid you $250, correct? And Tracy Attila's parents have paid you $250, correct?
That's correct.
And for this, all 3 families have been forever released from any liability concerning the fire, right? Now, am I correct in saying that Daryl Claiborne's mother had only paid you for the broken window
Yeah.
and no more, right?
No.
So Daryl's mother is the only parent that did not enter into some sort of financial agreement with you, right? So Mr. Fink, now it's Daryl, the only skateboarder who does not have an agreement with you, who you're trying to pin this whole accident on, correct?
It was also the only skateboard that was found on the premises.
Mr. Fink, there was 1 out of 4 skateboarders that were found on the premises that night that is a defendant in this case, right? 4 skateboarders, 3 financial agreements, and 1 defendant, correct? Your Honor, I have no further questions.
Thank you. You may step.